Assalamualaikum dan selamat pagi kepada semua peserta yang hadir pada hari ini. Okey, hari ini kita bersama-sama memulakan siri pertama Bicara Inovasi pada tahun 2024 yang bertemakan Cakna Harta Intelek. Saya berasa begitu bersemangat ya pagi ini kerana kita akan mendalami dunia yang menarik mengenai harta intelek yang semakin penting dalam memacu inovasi dan kemajuan. Sebelum kita teruskan, izinkan saya memperkenalkan penceramah kita yang ulung pada sesi kali ini. Datuk Sri Mohan bukanlah nama yang asing di dunia perniagaan dan inovasi. Beliau juga merupakan pengasas dan pengarah urusan Adastra IPM Sindram Berhad, sebuah syarikat yang menjadi rujukan dalam permohonan paten, cap dagangan, reka bentuk perindustrian dan varieti tumbuhan. Lulusan dalam bidang kejuruteraan dari Nottingham Trent University, United Kingdom, Datuk Sri Mohan telah menjejakkan tapaknya sebagai pemimpin dalam industri harta intelek sejak tahun 2004 lagi. Melalui kebijaksanaan beliau, Adastra IP telah berkembang dengan pesat dan memperluaskan sayapnya ke seluruh Asia Tenggara, India, Australia dan kini New Zealand dan Bangladesh. Dengan pengalaman lebih dari 20 tahun dalam bidang harta intelek, Datuk Sri Mohan telah diiktiraf sebagai Best Patent Agent untuk tahun 2012 oleh Perbadanan Harta Intelek atau lebih dikenali sebagai MyIPO. Beliau tidak hanya berperanan sebagai pengusaha, tetapi juga sebagai penceramah, penilai dan panel juri dalam pelbagai seminar dan program harta intelek yang diadakan oleh institusi pendidikan, kerajaan, agensi kerajaan dan sektor swasta. Jadi sebelum kita teruskan, saya ingin mengingatkan kepada para peserta untuk bersedia mengambil nota dan bertanyakan soalan apabila sesi soal jawab bermula. Tanamkan dalam fikiran kita bahawa inovasi dan harta intelek adalah kunci kepada kemajuan masa hadapan. Untuk makluman juga, smart attendance akan dipaparkan di akhir program ini. Jadi dengan itu, tanpa membuang masa lagi, saya serahkan sesi ini kepada Datuk Sri Mohan K untuk berkongsi ilmu dan pandangan beliau. Terima kasih. Dipersilakan.
Terima kasih Puan Najwa for the introduction. Good morning, everybody. So today I'll be talking about intellectual property and how you would be able to benefit from it. Predominantly, my speech will be in English, but please feel free to ask any questions at any point in Bahasa Malaysia. You can also ask me in English, that's fine. Firstly, I just want to correct a bit. My experience is from 1996, not 2004. So that's about 27 years of experience, just sharing. So much older than what you expected. Okay. So what I'll be talking about today is on the basics of intellectual property. I believe most of y'all would have heard of these terms: trademark, patents, copyright, industrial design, trade secret, and IP itself. So at the end of my talk, or in between, I would have an exercise. And I hope the audience over here would know the differences between all these terms. That's one of the first challenges that we're going to try to see whether I'll be able to, in this 45 minutes, give you an overview of everything on IP so that you'll be able to answer the questions that I'm going to pose to you as an exercise. And then I will also be talking after that about commercialization, some of the inventions that I've helped universities to commercialize, actual cases, and we'll also talk about IP valuation. So that will be the topic today. I might end at about 11:30, and then we can take Q&A. But in between, please feel free to ask any questions in between. You don't need to wait at the end of my talk to ask questions. I'm talking to a screen, and I believe there's about 100 of y'all over here, but I would really like it to be as interactive as possible. Only then would I also feel that you're benefiting from it. So you have any thoughts that comes to your mind when I'm touching on any of the topics, please feel free to just interject and ask your questions. Is that okay, Najwa? I mean, anything you would like to suggest? It's okay, yeah? Okay. So to start off with, You can see my screen. It's all clear. Okay. So to start off with, as I said, intellectual property is the main body. Under intellectual property, you have trade secrets, patent, trademark. I'm going to touch on every single one. But the most important thing is IP. When you look at IP, just as the name says, I mean, property, when you look at the word property, you feel it's an asset, there's a value to it. When you have a property, there's a value to the asset that you're holding. So similarly, when you have an idea, what we would do is we will actually protect the idea so that it become valuable to you, and it will also be an intangible property to you. And you will have some value to these ideas that you have. And the way we protect the ideas would be in the form of the tools that they've given, whether it's trademark, patents, copyright, or industrial design. And once it's protected, then it will be, we will have a value to it. It will become an asset of yours, of the applicant who files it. So intellectual property is the umbrella. Under intellectual property, you have trademarks, which protects the name or a logo or a tagline. You have patents that protects technology, copyright that protects artistic work, geography indication that protects GIs, and industrial design that protects a shape. So I'm going to touch on each one of it, but to start off, let me just talk about trademarks. Every business will have a trademark. There's no business without a trademark. This is key. When your researchers or anybody in the university who's working on a technology, when you get into a business or when you have a spin-off company, the trademark is key. Patent is also important for you, but trademark is something that you really need to consider. So to protect a trademark, it can be in the form of a name. It can be even a logo. It can even be a tagline. For example, the city never sleeps. That's a tagline by Citibank before. Now everybody can fly is also a tagline. So they can be protected. The examples that are given on the side are actual cases that we have actually protected for our clients. Okay, Friendster about 2000 and about maybe 15 years back, they actually came to us, and a Malaysian company, MOL, bought over Friendster, and they bought it for about 100 million. And when this company was bought over at that time, many people questioned why was a Malaysian company buying Friendster for such an expensive price. But when they actually, but once they got the trademark, once they got the name protected, and also they got the applications in, I will share with you later when I'm talking about patents, how the company, Malaysian company, actually made quite a bit of money from it. They actually made money from Facebook, but I'll share with you later when I'm actually talking about patents. So trademarks, as I said, every single business will have it. If I can just give you an example, because we Malaysians, sometimes we look at stalls, we'll be thinking, I mean, they're only a stall, they will not have any trademarks or any IPs to protect. I just want to give you the misconception of that. Even a stall owner may also need a trademark. For example, a local brand, which is pretty well known now, it's called MVG, Money Back Guarantee. MVG is a fruit. They sell fruits predominantly. So when they first started, he was actually running his parents' business in the market, the owner. And when he took over from the parents, what he did was he just put a signboard in front of his stall, and he called it MBG. So many of the other stall owners looked at it and they were like looking at him, why is he putting a brand in front, MBG, in front of his stall? But what happened was people started recognizing the concept behind this brand, MBG. When you don't really like the fruits, you can always return it. He came up with that sort of concept, which is really very interesting. Everybody else just had a stall, but there was no name. There were many stalls, there were fish stalls, there was also people selling fruits, but he just came up with this concept. When people recognize this, when they go to even other markets, and he opened up in other markets, also opened up the same store, and then he had MBG there. So they straight away understood the concept, and they used to go to his store. And when he had a few stalls in a few markets, he was also buying more products. So when you buy more products, because of economy of scale, you'll be able to get the products at a cheaper price. And he was able to also make. And you want to have Apple as a trademark? The answer is you can't. They will not allow it. Whether you're selling handphones and you want to call it Apple, not a problem. You sell shoes, you call it nose, no problem. But you sell shoe and you want to call it shoe, you won't be able to. Okay, so you can actually get a name from the dictionary protected, but you must make sure it's not descriptive of the product. That's important. So similarly, as I said, diamond, if they're selling diamonds or they're selling jewelry and they want to call it diamond, they want to call the brand or the shop diamond, then they will have an issue. But if they're selling water filters and they call it diamond, that's not a problem at all. Okay. Now, I'll just go to what makes a powerful brand. It's very hard to get the answer, but the most important thing that you need to look at is you must consistently use the same name again and again. For example, if someone is using MCI as the brand, use it consistently. If you use the logo, the font, the same sort of font, it's even better. For example, Air Asia, one moment they can't be calling themselves Air Asia, next moment ASEAN. They have to have it consistent. That's the most important thing when you have your brand. Always be consistent with the way you call yourself. For example, university is called UKM. You got to call it UKM throughout. Then only people recognize. Now, this is something that the book says, what you should do in order to have a very strong trademark. So these are the steps you need to take. You must make the name memorable. The name must be easy to pronounce, but not necessarily I agree with what this book says. Okay, this is what they say that you need to do, but I'll explain to you why I also don't agree with some of the claims that they say is important for you to have a good trademark. But I'll tell you at the end what is the most important thing you need to do. So they say it must also be easy to pronounce. So when you want to have a good trademark, it must be memorable. It must be easy to pronounce. But let me give you an example. Can anyone in the crowd? I know you're muted, some of y'all, but can you all unmute yourself and tell me, what do you think this, how do you pronounce this? Can anyone say? Anybody from the crowd? Maybe for Najwa, you want to try? How do you pronounce this name?
Can I try?
Okay, please do.
Maurice Lacroix.
Okay, it's Maurice Lacroix, it's Maurice Lacroix. It's a Swiss brand. Yeah, it's a Swiss brand. It's quite well known. So, they say you must get something which is easy to pronounce, then only you'll have a good trademark, but not necessary. This is a very well-known brand in Switzerland, at least, and it's a high-end watch, and they call it Maurice Lacroix. And there was also a few years back, this was about maybe 20 years back, an air fragrance, which is called MB Pure or MB Pur. Even now, I do not know how you pronounce it. But even the way to pronounce it was a gimmick. They had an advertisement. How do you pronounce that word MB Pure or whether it's MB Pur? So it was so difficult to pronounce, but it was a gimmick at the end of the day. And they even had advertisements to teach people on how to pronounce the particular word. So what I'm trying to say, although the book says you should get a word which is easy to pronounce, but I would just say if you really like the word, even if it's difficult to pronounce, it may still be successful. Then they also say the name must be easily associated with the company's product and services. Now, this again may not be true. Some of y'all may be able to cook over here. Can I just ask you, what is the most famous sardine brand in Malaysia? Can anyone just tell me what's the most famous sardine brand in Malaysia? Anybody? Please unmute when you're saying the answer.
Ayam brand.
Ayam, right? You just said ayam. Okay, you're right. Ayam is chicken, sardine is fish. It's not associated at all, but it's the most famous brand. Okay, so the book again says you must get a product which is easily associated with the product and services, but not necessarily. As I said, Ayam brand is a good example. It means chicken, but they're actually selling fish, and it's so successful. Then the book also, they also say for future expansion, you need to have like a multinational kind of name. They say that. But again, that is why you see a lot of Malaysians, whenever we want to get a name, we'll come up with something like Dipute, trying to sound a bit Italian, and then Le something is trying to sound French. We want to do that. But it's not necessary. If you really like to add Deep something or Le something, it's fine. But you don't really need to do it just to sound international. Because even if a name sounds a bit local, but if you have a good service, you have a good product, it can still sell. And I'll give you an example. Although this is UCAM, I'm going to give an example of another university, a private university, which is doing very well overseas. And it's called Lim Kok Wing. The name can't get any more Chinese than Lim Kok Wing. but he's doing so well in Africa, in Botswana, and I filed a trademark for them, not only in ASEAN, but also in African continent. And they're doing so well. And they did not change the name to sound, French or to sound Italian or to sound American or to sound English, but they're still doing very well overseas. So sometimes if you have a name, you really like it, you can actually protect it. The most important thing you need to do is you need to make a search. Traditionally, people used to come to us to make a search, but now with Google, you can just make a Google search. If you see the name is not being used by anybody, then it is fine for you to use the name. But in case you see the name is being used by another person in the country for the same services or product, then you should really think twice from using the name. Because when you come out and you start using the name, they might come after you. They might say that you're infringing their product. Okay, now there might be a scenario where you don't find the name in Malaysia, but you might see the name in another country. Maybe there might be a similar name in Singapore. Now, again, if it's for the same service or same products, then you should also not necessarily use the name, because if you want to expand into another country, you may have a problem. You might just be able to build it in Malaysia, but when you get into Singapore or the neighboring countries, you might have a problem. So how can you grow? So it may not be really good. So the most important thing which you need to do in this case is make a search, see whether the name is available. If it's available, then you would be able to use it. Now, there's another thing in trademarks that you need to also take into consideration, and that is the classes. There are 45 classes in trademarks. So if someone has protected the name under the restaurant class, you may still be able to use the name to sell shoes, probably. If it's not really a well-known mark, you would be able to do it. Okay, so again, just because a name is already used by somebody else, you need to see whether the name is used for the same product or services that you want to come up with. Because if it's not, there is always a possibility for you to still use it. Has any one of y'all had any issues with trademarks previously, before this? Or any doubts that you've had? Everybody is quite clear? Fine. I mean, I'll just give you another example. Have you heard of the case McCurry and McDonald's? Anybody has heard of that? Okay, so the case was a few years back, I mean, maybe about 10 years back, where McCurry was sued by McDonald's. McCurry is actually a mama restaurant, and most of y'all know of what McDonald's, and it's the fast food chain, restaurant selling hamburgers. So McDonald's, I believe, was not really losing any business. No one was getting into McCurry and asking for Big Mac. McDonald's was not losing any business because of McCurry being present. But the reason why McDonald's, I believe, took action against McCurry is because they didn't want to dilute the name. If they just allow McCurry an easy ride, then you will see other people coming up with more Mac something restaurant. So because of that, they cannot dilute the name. They actually took action against this other party. Now, they may have lost the case. They may have lost the case. But when you talk about business-wise, they have won. Because you still see McDonald's around, and they've also expanded. But you don't see McCurry anymore. So McCurry, as a business, it's lost out because they were fighting the case, and the focus was more on winning the case or fighting the case in a way, and how do they pay the lawyers. McDonald's can set aside a certain amount to just fight the case, but for McCurry, it was a bit of a struggle. At the end of the day, even when they won the case, but they really could not do much because the focus was really off. I mean, they were really looking at fighting a case and not really building the business. So it was a bit unfortunate, but that's why McDonald's took a case against them, because even though they knew it was not really a very strong case, but they had to actually put a stop because they didn't want to make it seem like a person can just use a very similar sounding name and try to get away with it. McCurry came up with the excuse, I'm using MC curry because I'm selling Malaysian chicken curry. MC is Malaysian chicken. But come on, they're also selling fish curry there and also mutton curry. Why not they call it MF curry? You know, why MC curry? Because it's quite clear. I mean, the intention was also to ride on the goodwill of McDonald's probably. Okay. Now, I want to share with you another example that actually happened to us. This was a talk that I gave about in 2014 or 15. I gave a talk at a certain place, and one of the event organizers over there was also present, and they had a different company, and I gave a talk. And at that point, I really didn't think our brand, Adastra, is the company Our IP firm is called Adastra. I didn't think it was all that well known. The following year, after giving this talk, I met the same event organizer, and the event organizer presented me a new card. And when I saw her new card, her name on the new card was Adastra Network. Our company is Adastra IP. And just 1 year back, I gave a talk at her event. And the following year, I see Adastra Network in that card. To us, that's such an insult because I go around telling people to protect the trademark. And now I have someone using a very similar trademark to mine. So it was very embarrassing for us because we are preaching and telling people you should protect your brand. But in actual fact, we can't even protect our brand in some ways because someone else has taken a similar kind of brand. So what I wanted to also highlight here is many of my clients, when you tell them, why don't you file a trademark? Then they will go like, yes, I've already protected it. I went to SSM and I've already protected the company. That's good enough. I say, no, you're protecting the company. That's Sandian Bharat or as an enterprise, but you're not protecting it as a trademark. It's not good enough. But sometimes they don't really understand. And this is a good example where Adastra Network went to SSM and they managed to get the Sandian Bharat protected. So it was a bit disappointing for us that they managed to get this protected as a company. So what we did was we went and spoke to them and told them, look, you have a very similar name to mine. Please, you got to change your name because it is not looking good on us. And you got the name after seeing us. They did not agree. So we had no choice but to take action against them. So we actually took a legal suit against them to say that you have to stop using Adastra Trademark Network because it's very similar to our name. And because of trademark, because I could rely on the Trademark Act, that is why the party started listening to us and they agreed eventually, after us putting up a fight, they agreed to settle the case and they said, okay, fine. We will now use the word together as Adastra Network and we will not split it up because once you split and you see Adastra and Adastra, it looks very similar. It's confusing to my clients because clients have even asked me whether I have a link with this company. So that is why we insisted that they have to join the name together because when the name is together, like what you see on the screen, then people will say Adastra Network. It's different from Adastra. So from this example, you can see why trademark is important for one to file because without a trademark protection, I would not have been able to stop this party from proceeding by using a similar name. Because under SSM, they allowed Adastra Network to actually get it registered. But under trademark law, I could actually stop them. So this is some of the advice that I give my clients. You need to actually protect it under trademark law and not just base it on SSM. Now, another thing you need to also understand is trademarks are protected territorially. If you're protected in Malaysia, you're only protected in Malaysia. You want it protected in any other countries, you need to file it in those countries as well. So again, a typical question I get from my clients is, if I'm going to file in 200 countries, it's going to cost me a lot. So why is it so expensive? Now, I will always tell them, look, if you're only having a business in Malaysia, just think of Malaysia, just protect Malaysia first. Once your business does well, then you start thinking of the neighboring countries and you start protecting in the neighboring countries. You don't need to straight away think about protecting the 200 countries on day one. You can always go step by step. So it is not really an expensive process. We have ways we can talk to you. We can come up with some strategies, cost-effective way for you to actually protect your brand in various countries. For example, we can cover 1/3 of the population with just about 10,000 ringgit, but 1/3 of the population you can cover, protecting your trademark. We can always talk about it at another point. If you're really interested, you can contact us. Another thing you must also consider is Madrid Protocol. So there is one application that you can file. You can go under Madrid Protocol. You can file an application under Madrid Protocol, a trademark under Madrid Protocol, and cover the countries under Madrid Protocol if you're interested. If you are going for more than 4 countries, maybe this is an option for you to take. You may want to protect yourself under Madrid Protocol. If you're going for more than 4 or 6 countries, it might be cost effective. But if your growth is a bit organic, you're not really having exponential growth in your business, then probably just filing it in individual countries may work for you. So that's a strategy we can always talk. If you have more questions, you can always ask me. Then I can tell you when is a good time for you to go for method protocol, when would be a good time for you to just go on to individual countries. Okay. Now, the next type of protection that I would like to talk about is industrial design. So first I spoke about trademarks. Trademark protects a brand.
Sorry, Datuk Sri. Maybe,
Yes, sure.
we have a question. Maybe Miss Najwa will. We have a
Boleh.
question on
Boleh.
the chat box. Miss Najwa.
Ya, boleh.
Saya akan
Boleh?
bacakan
Kan
beberapa.
Hmm.
Okey. Daripada siapa Sir, is it correct to say that a trademark is also a brand and they are the same?
Okay, but basically your brand is what represents your company. And trademark is when we protect your brand. When we protect your brand, we protect it under the trademark law. We protect your brand under trademark law. So then you can say that that's your trademark and it's also the brand of the company. So it is interrelated. But when it comes to trademark, you also are relating it to the Trademarks Act, which is under the law. So your brand is a representative of your company. And once you protect it, it becomes your trademark. So it is related, but it's just that trademark is a protection of your brand. Okay, does that answer your question? So it's related. You can say that, yes, this is the name that represents my company. It's my brand. And I've also protected under Trademark Act, and it's now my trademark. Okay. Is that the only question?
Okay, sir. How do Malaysian businesses leverage branding strategies to differentiate themselves in the domestic and international markets?
Okay, it's a very general question, but okay, firstly, that's why you file a trademark. That's why you need to come up with a brand, because you need to differentiate yourself from all the rest. See, previously, when you get into there are many people doing business from houses where they come up with cookies. I think you go to petrol stations, you will see during Raya, they will have cookies. Most of the packaging will be the same. Most of the cookie packaging will be the same. Or they have Propo also. They will be selling Propo in a plastic. I'm talking about, maybe 15 years back. I used to always, whenever I give a talk, I'll say, when you have these cookies, why don't you just put a brand on top? Whatever, whether you want to call it Fatimas, just put Fatimas on it to differentiate yourself from all the other cookies. Because if you go back 15 years or even 20 years, when you get into the place, you'll only see the packaging, but you won't see a brand on it. They'll only have a packaging, they'll have the pricing, and they'll have the ingredients. That's about it. So if you eat it and you feel the food is quite nice, you really like the taste of this Propo, when you want to go back and you want to tell somebody, you got to look out for this particular Propo, it's very difficult because there's no brand. So I used to tell the business people, even though you're small, start putting a brand on your product so that you differentiate yourself from the rest. That is why you have this brand. That's why you file a trademark, because you want to differentiate yourself from the others. So that is key, because if you do not differentiate, even if you have a good product, how will people be able to come back and buy the same product? So I want to just give you one more example. Even a goreng pisang seller. Someone is selling goreng pisang also. The stall is doing very well. You have a long queue. In no time, another 2 or 3 more stalls will come by the side of you. Just because he's doing well, there'll be so many other stalls. So all the stall owner needs to do is just put a signboard there, maybe Ali's goreng pisang, for example. So people can say, when you go to Jalan Bangsa, you see a stall by the side of a traffic light, look for Ali's. Because otherwise, it's very hard for someone to say, go back to this stall and buy this product, which is good. So that is why every single business, I keep insisting, should have a brand. And once you have a brand, as your business grows, you need to start protecting it so that you will cover yourself. Now, not only in Malaysia, because when you protect it as a business in Malaysia, you might also have a chance of growing it in other countries, replicating the success story that you have in Malaysia and other countries. So you need to also now start finding, as I said, in other countries as well. So that's important. So that's where your strategy comes in. So for example, if you come up, now sambals are also doing very well. You come up with a sambal, you have a brand. You may not necessarily manufacture a sambal in another country, you can always license it to somebody else, use your name, provide, and then you'll give them the trade secret on how the sambal is made, probably. And when they make it, they can label it, use your product, and whenever they sell the products, they pay you a certain royalty for the name. So you may not need to go there and open up a shop. You can just license your name. So that's some of the strategies for you to grow your business in other countries. You can license your name, and some eventually will call it a franchise. Okay, so this is something which is important when you're expanding your business. The brand is really very key, very important. Okay. So there are strategies
next
that you need.
question.
Okay, sure.
Okay, sorry. All right.
Thank
Do
you
you
for all the
agree the
questions. I'm
government
really
should provide support and protection for entrepreneurs like me as we start and grow our businesses here in Malaysia?
okay. It's interesting you're saying that. I mean, I'm okay for the government to give some assistance, and the government is giving. If I can share with you, firstly, my IPO has got a dana. If you want to have your patents protected and some of your trademarks as well, they have a limited amount that they give out a dana for you to protect. So they do have some amount of assistance. I think Teraju also under Superb Fund, they also give out some funds for you to expand on your business. So look out for some of the assistance that's given out by the government. So, but I just want to share one thing with you. A trademark doesn't cost too much. The patent office charges 950 ringgit for you to file a trademark. That's the total fees for the next 10 years. So it's only 950 ringgit. So if you're doing a decent business, for you to come up with 950 ringgit should not be too much. If you employ people like us, I mean agents to file it for you, yes, we'll have a professional fee. But the professional fee, you can shop around. It should not be too much. It won't be that expensive. But you can even go to the patent office. We are more than happy to just help you to go directly and file. And we will be teaching you also how you can file it on your own. You can always contact me. And I can always share with you how you'll be able to file it at the patent office, at my IPO, which is in PJ, the application. And all you need is just 950 ringgit and you're protecting it in Malaysia. So the government gives some amount of assistance. But what I'm trying to say is not necessary for you to be too dependent on it because the cost is not really that expensive. Many people have this impression, filing trademark and all may be a very expensive process. It is not so expensive. Okay, so you don't really need to worry. But anyway, even having said that, they do have this dana. My IPO also has got a dana where they assist some companies, which are small companies or individual inventors, to protect the IP, patents or trademarks, where you only need to pay, or you don't really need to pay, because as long as you get some approval. Okay. Does that answer your question? I mean, Najwa, is it clear? The answers are clear.
Yes, clear. So
Okay.
now I think you can just continue the
Continue. All
slides
right. Okay,
in
sure.
your presentation.
Okay, sure. So next, I'm going to touch on industrial design. So as I said, under IP, intellectual property, you have trademarks that protects the name. Now, you may also come up with some ideas. Some of your researchers or some of your staff in the university, in your faculty, might come up with a nice, packaging for your product or nice housing for your particular product. Then you can protect it under industrial design. So industrial design doesn't protect anything functional. It only protects the aesthetic value of a particular product. For example, if you look at a handphone, the shape of the handphone is protected under industrial design, just the shape. In some industries, this is very important. The watch industry, the specs industry, car industry, the designs are very important. If you look at the technology is fairly similar, but it's the design that differentiates it together with the brand, of course. If you see a specs and it's Ray-Ban, it'll be a certain price. If no brand at all, it'll be much cheaper. If it's Prada, it's even more expensive. Okay, so brand also will cost, but also the shape. So in some industries, you need to provide a shape. If I can give you an example, you look at the furniture over there, a chair, which looks like Angelina Jolie's lips, quite big over there. So that is protected as an industrial design. Now, that doesn't mean no one else would be able to come up with a chair with the lip shape. If someone comes up with a lip-shaped chair, but it's a one-seater where it's more like, like a lip longish, then that's a different design. So industrial design protects very limited. It's only for that particular shape. An example, if I can give you, there's diamond water by the side. I don't know how many of y'all have come across diamond water filters, but that's a very typical look of how a diamond water filter looks. I told you earlier, this was one of my first clients about 20 over years back. They called me up, they said, I've got a fantastic mechanism inside, a novel mechanism to filter water. I want to protect it as a patent. I said, no problem, I'll file it for you as a patent. The mechanism kat dalam the housing of the diamond water filters. I protected it as a patent. Lepas tu they said, okay, why don't I, diamond, I want to also protect that as a trademark. I said, okay, fine, I've protected it as a trademark as well. Then I told them, your shape of your dome is very unique. And even the color is blue color and it's very unique shape. Why don't you protect that as an industrial design? I told them. Then the reply back to me was, they just asked me a few questions. Mine is like a dome shape. What if someone come up with a cylindrical shape? Will that be protected? I told them, no. I said, no, it won't be protected, okay? Then they said, okay, what if someone comes up with a square shape? I said, no, it won't be protected because yours is dome. Then they said, then it's very limited protection. Only dome, if someone comes up with cylindrical, someone comes up with triangular shape, or, something square, I cannot really protect. What's the use of protecting it? Not necessary. They just told me. So I only protected the patent, the mechanism kat dalam, and also the diamond, the name. But I did not protect the shape because client said, I told them also it's very cheap. At that point, I remember it's about 1,500 ringgit. Even now, it's not all that expensive to file an industrial design. It'll be 2,000 plus only to file an industrial design in Malaysia. So I told them it's about 1,500. Why don't you protect it? They said not necessary. Now, 5 years down the road, they became very popular, very famous. So then I got a call from them. They said, Mon, I need to see you. I went and see them. Then they said, somebody is copying me. I said, oh, okay. Then they told me the mechanism kat dalam, they're not copying. So they're not infringing the patent. The mechanism inside, they're using a more inferior mechanism. They're not using the proper mechanism. They're using an inferior mechanism to filter the water. That means the end result, the filtration is not so good. But customers can't see that. Customers only see the housing. They cannot see the filtration kat dalam. Then they are not also protecting the diamond. They're not copying the name also. They just have a blue dome. There's no name over there. And the mechanism kat dalam is also not the patented mechanism. So they said, because when customers go into the shop and they see this blue dome and they see diamond blue dome, they know this is infringed. They know it's infringed, but because the price is half the price, they say, oh, this is infringed, but it's not branded, but it works the same. So they feel it works the same, but it's not branded. So, and because it's half the price, they go for this infringed product at the end of the day. So Diamond Water was actually losing on business because there were customers going in and looking at this infringed product. At that point, because I could use copyright law, because the law was under the old act, where I could still use copyright and go after the other party, and we managed to stop the other party. But now with the new act and all that, I can't really just change and rely on copyright law, because if you produce more than 50 products, you need to fall under industrial design. So it would have been a challenge if the same thing happened now. I would have had a difficulty stopping the infringer. But at that point I could. So what I'm trying to say here is, if you come up with a really nice design for your product, whether it's a furniture, a nice furniture that you've come up with, a nice chair, a nice table, very good design, you have to protect it under industrial design. Because if you don't protect it, you will not have it, it won't be covered. And when you don't have it covered, it's not your IP, it's not your asset anymore. So industrial design is also key, it's also crucial, and it's not expensive. So you should consider filing industrial design for any housing or any designs that you come up with is special. Okay. Next, sorry. Next, I want to touch is on copyright. This is also under intellectual property, but copyright protects the artistic work. Whenever you come up with something artistic, literally or dramatic or musical works, then you protect it under copyright. So songs is protected under copyright. Now, unlike patents, industrial design or trademarks, where you need to go to the patent office and file it, only once you file, you have it protected. Because if you don't file, you don't have it protected. Copyright, not necessary. Copyright, if you want, you can voluntarily go into the patent office and file. But if you choose not to, you can still have copyright for it. For example, I give this example all the time. If I sing a song right now and you take a recording of me singing the song, and I say no one else has sang the song, but just hope I don't sing the song, all will leave. But anyway, if I sing the song right now and I take a video recording, I can claim I have copyright for the song, provided that I'm singing a song that no one has heard before. So I can say this is a song that I've created because I have a recording to prove the earliest date of creation. Now, if one of you can actually show that you sang the same song 1 month before this date, because I'm singing it right now, 1 month before this date, then you have an earlier date of creation. So you automatically have copyright for that particular work. And as long as you've published it, you will have copyright for it. So where copyright is concerned, you don't need to go to the patent office and file it formally. You would be able, as long as you can prove you have created it on a particular date, you will have copyright for it. Okay, so if you take a photograph of something and you think the picture is really nice, you need to just mention when you've taken the picture and you're the owner of this particular product, of that work, and you will have copyright, and you publish it and you will have copyright for it. So if anyone else wants to use your picture, they have to pay you a certain amount of royalty in order for them to use the picture, or they have to credit you for it. If you say, okay, you don't need to pay me anything, but just give me credit, then they have to credit you. They cannot just simply take and use your product. Okay, so copyright is fairly simple. So like this slides that I'm preparing, no one would be able to take just my slides and give the same slides and talk about IP. They can always talk about IP, but they cannot use my identical slides. They have to tweak it, they have to change it. Okay, so that's one copyright. So whenever you come up with any sculptures, any drawings, any paintings, you cover it under copyright. One mistake universities normally make, and I want to bring this up to you, is they think they're protecting the technology, the patent, under copyright. That's very wrong. For cost purposes, sometimes because patents can cost a bit more, they would say, I'm protecting, I want to have it protected, I'll protect it under copyright. But when you protect your technology under copyright, technically you're not protecting the technology. You're only protecting the expression of how you're presenting the technology. That means the writing, the write-up. You're only protecting the write-up. You're not protecting the end product. Okay, so that's something you need to have in mind. So it's only the write-up that you're protecting. So if someone takes the write-up of your technology and they produce the write-up somewhere in another journal, yes, you can take copyright action against them because they've copied your write-up. But if they come up with a 3D version of that write-up, of the product itself, they come up with the product of the technology, you will not be able to stop them. That is why you need to file a patent. I'll touch on patents later. So whenever a researcher tells me I've protected my technology under copyright, honestly, it's not much protection. More like shock sendiri lah. I got some IP, but it's not really going to do justice to you. If your invention is really very good, you have to go for patent, because otherwise you're not protecting your technology. You're only protecting the write-up. Please keep this in mind. Okay, so copyright protection for technology is not the right way to go. But for artistic work, no problem. Okay. Sorry.
Okay, we have question from the
okay, sure.
chat box.
Hmm.
Can we register for copyright if we made a digital comic using Canva? The copyright of each image characters is owned by the person who created or uploaded into Canva. But some said once you make your own comic design in Canva using Canva items, you can IP it.
Yeah, so you're using Canva, but you're coming up with your own characters. The character is something you have created. So you would be able to have copyright for the characters that you have created. I need to see if there's any terms in that agreement where they say anything that you create from this will also belong to Canva. I'll be surprised. I don't think it's possible. But again, I need to see. If they put some kind of restrictions like that, then no one will really use Canva. So if the character is something you have created, just like Mickey Mouse, Mickey Mouse is created by Disney, and they created that character. And when you come up with the merchandise, when you come up with the artistic work of that particular character, it will belong to the person who created it. So you would be able to actually get copyright for the character that you have created, even though you're using a software to do it for you. Unless, if you really look at your terms, if they say that whatever you create here is going to belong to us, then no one is going to really use that particular software. So the answer is, if you have created a character by yourself, you've come up with a character, it will belong to you. So you should protect it as yours. Okay. Anything else, Rancho?
Okay, there's one message. Okay, so
Feel
it
free to
seems
contact me at
like
any
you
point.
don't want to share your slides today because of copyright.
I'm sharing my slides. Yeah, there's no copyright. You can use it if you want to, but just make us, give credit to Adastra that you're using Adastra's slides. Okay, go on. Sorry, what is your question?
Okay, that's all.
Oh, what's the question? They said, do you want to share? What was it? What's the comment?
It seems like you don't want to share your slides today because of copyright. Ha ha ha. Just like
Yeah,
that.
oh,
It's
okay.
a statement.
No problem. I mean, I'm willing to share. We will.
Okay.
You can always contact Puan Najwa later, and then you can get the slides. No problem at all. Okay, next one that I want to touch on is trade secret. Now, there are certain cases where if you think you can keep your technology as a trade secret or know-how as a trade secret, then do it. Because if you keep something as a trade secret, you'll keep it forever. If you file it under a patent, you'll only have 20 years protection. If you file it under patent, if you have a know-how or you have a technology which is really fantastic, you protect it, you only have 20 years. But if you can keep it as a trade secret, you'll have it forever. Now, there are two very well-known trade secrets. Konon, people say that's a trade secret, is Coca-Cola formulation and also KFC formula, for frying chicken. So they say it's a trade secret that they've been keeping it for hundreds of years. There's also a myth. I don't know whether it's a myth or whether it's true, but people say there's only 5 people in the world who know Coca-Cola formulation. And these 5 people cannot go on the plane together because in case the plane crashes, then nobody will know the formulation of Coca-Cola. I really don't think it's true, but I do not know. So that's all a bit of, they're just making it look like, it's very hard for one to get a trade secret, because the problem with trade secret is, how are you going to keep it as a trade secret? If you're keeping a formulation as a secret, somebody needs to mix the formulation. So you need to share it with your staff. They can sign a non-disclosure agreement, but sometimes they can quietly go and speak to another friend of theirs or kid of theirs and say, this is the formulation, go and do it on the side, don't bring my name up. I mean, things can happen. So that is why I said it's going to be really challenging for one to keep something as a trade secret. But if you really find a way, so some of my clients, what they do is, in case there are 3 parts to the product, to the technology, they'll manufacture this from a separate person, the center portion with a separate person, and then the third portion from a separate person. Then they'll have another side that does the whole assembly together. And then they will keep it as a trade secret like that, because every single part, they'll break it down into several sections, and each section is being done by another person. And then they will have an assembly unit that puts everything together. If you can really figure a way out to do it, and you have a non-disclosure agreement put in place, and you take all the precaution to keep it as a secret, maybe you might be able to get away with it, but it's not so easy for you to grow your business. And also, if someone else can, with trial and error, they figure out your formulation and they go and file a patent, they might even be able to come after you. So if you're going to keep something a trade secret, you really need to be very certain that it's very hard for someone to actually reverse engineer and come up with the end product. Because if they do, then you will lose out quite a bit. Okay, so there are many companies, I know that they look for trade secrets, but if something is patentable, maybe you should consider filing a patent, because 20 years is good enough for you to exploit and make money from your technology, because technology keeps changing. You may not need it for 100 years. Okay. So that's on trade secret, which also falls under IP. If you can really keep some of your products as a trade secret, it's good for you, but as I said, it's challenging. Okay, the next, and this, if there are researchers in the audience, this would be really relevant to you. Because when you come up with your research work, especially on technology, you will need to file a patent. This is the most relevant. Trademark only protects the name. Industrial design only protects the shape. the technology is actually protected under patent, not under copyright. Copyright only protect artistic work. Okay, that means the form, when you come up with the write-up for your journal, the write-up for the journal is protected under copyright, but not the product itself, not the technology itself. Okay, under patents, you need to firstly see whether your whatever that you've come up with, does it fulfill this criteria? It must be new, it must be inventive, and it also must be industrially applicable. These are the three criteria you need to fulfill in order for you to get a patent. First two, let's consider first two, because industrially applicable is quite simple. As long as you can use it in a particular industry, and we can always find that you will qualify for industrially applicable. So you don't need to worry about that. But the first two is the most important. It must be new. So it must not be anticipated by any prior art. That means there should not be another technology which is similar to this before you came up with the invention. And two, it must have inventive step, meaning the test is, it should not be obvious to a person skilled in the field. It should not be obvious. So as long as it fulfills this criteria, you will be able to get a patent. I want to give you an example. I want to give you a few examples so that you'll understand where I'm coming from. Now, normally I have face-to-face. It's easy, but now I'm talking to the computer. Okay. Now, just imagine, please, all of you, just imagine if all chairs in the world had 4 legs. All chairs in the world had 4 legs, okay? Just imagine. There's no chair in the world with 2 legs, 3 legs. All chairs had 4 legs. Now, if someone comes up and tells me, I have a chair with 5 legs, 5 legs, would that be an invention? Yes or no? I know we Malaysians, we don't like to sometimes voice out our opinions, but I think your researchers and university lecturers, I think you'll be a bit more braver. So can you please, there's no right or wrong answer here. I just want to understand. When all chairs, just imagine all chairs in the world have 4 legs. Now, one of your researchers comes and sees me and says, I got a chair with 5 legs. Do you think that's an invention? Yes or no? Anybody? Can someone say?
Hi, sir. I'm Haliza.
Yes. Yes. Aliza, yes.
Okay. To me,
Chair
cannot
dengan 5 kaki.
yeah, a pattern. Because anything that you do, it must have a function, right? So in this case, if the legs doesn't have any function, so to me, you cannot file for a patent for that kind of innovations. Yeah.
Okay, very good. Okay, very, very good. I appreciate you trying. Your answer is right. Your answer is right. But the reasoning you're giving, I just want to elaborate a bit more on the reasoning. Tapi answer you betul lah. You cannot protect it. Firstly, let's just go into the criteria yang saya bagi tadi, okay? It must be new. So, a chair with 5 legs is new. Because all chairs had only 4 legs, now you have a chair with 5 legs. It is new. So, it fulfills the first criteria. It's actually very good. But now when you go to the second criteria, it must involve inventive steps. So, it must not be obvious. Now, to add another 5th leg, it's so easy. Anyone, even a school kid, can think of adding a 5th leg. Just like how I can think of adding a 6th leg. I mean, I can have 6 legs. I can have 7 legs. It doesn't take a genius to do it. So because of that, it's obvious. So under this criteria itself, it will fulfill the first criteria and it can fulfill the last one, industrially applicable, because furniture companies is an industry as well. But the second criteria doesn't fulfill. Because of that, it is not patentable. Because it's obvious to a person skilled in the field. Anyone could have figured this out. By adding another leg, how is it enhancing? How is it making it better? Now, there was once I gave a talk and someone actually brought up and said, yeah, but what if the 5th leg provides extra support that gives the spine a bit more support? So when the person sits, the spine has more support. Then it's possible, but you have to actually mention where must the 5th leg come out from? Maybe somewhere at the back. It cannot be from the front because you're saying you're giving some extra support to spine. And you have to have some kind of data to prove that, you know, it is actually providing some amount of support to the spine. And the person sitting on it for long hours would be able to, you know, improve the structure of the spine or something. So then you can show that it's not obvious. So you need to be a bit more specific. Where must the 5th leg be? At what angle must the 5th leg be? how must the support be given in order for it to absorb the user's weight, especially from the spine. So if you can actually show those kind of advantages, as what you correctly said, Haliza, first, because there's no purpose for it, but if you can show there is actually an actual purpose for it, the answer is yes, I may be able to file a patent, because I'll say it's not obvious. This is something I had to put a lot of thoughts into it. Okay? But what if all chairs had 4 legs, tapi now I'd say I came up with the invention, I have only 1 leg. Only 1 leg. Is that an invention? If I have only 1 leg? The answer is yes. Because when I have only 1 leg, I cannot take out 3 legs, because if I take out 3 legs, the chair will fall. Anyone who's sitting on it will topple. So you need to move the leg to the center. But even if you move the leg center, it's not stable. Then your base must be very big. You know, and you must have a structure to hold it also in place. The seat must be held in place. See, now you're putting a bit more thought. So if you're going to have only 1 leg, there's a lot of thoughts coming up. It's not obvious. You cannot say it's, you know, it lacks inventive step, because you really need to think. When you take out 3 legs, and if it must only support itself with only 1 leg, a user who's sitting on the seat must be supported with only 1 leg. The leg must be placed in a certain position. And the base also has to be a bit bigger, and it has to be strong enough to hold the user. So now you're making it's not obvious anymore, because you're putting a lot of thoughts into it. So a chair with 1 leg can also be an invention. Okay. So this, I'm just giving you an example of what would qualify as a patent. Okay. So you need to fulfill all this criteria. Now, it doesn't need to be something so super duper. A lot of people think also invention must be something like, I need to come up with a very fantastic technology which is very complicated, you know, AI based or something like that. Not necessary. It can be something fairly simple. Let me just give an example. This is a spoon. Okay, this is a spoon. Now, when you go to a restaurant, a mama restaurant, again, I'm giving mama restaurant, say Mac Curry. You go to Mac Curry, you'll see a pot. And in the pot, sometimes the spoon will be under the pot, in the curry, because it's already sunken in. The spoon will be in. How do you overcome this problem? I ask the audience, most of the time they'll say, have a hook. When you have a hook, you can put a hook at the end of the bowl, and it will be able to hold the spoon so that it won't sink into the gravy. That's one. Can anybody tell me there's another way you can actually prevent this from sinking? What can we do? An example, please. Can someone tell me how else can you prevent? Okay, let me give you an example. What I need to do is, this is the spoon. This is the spoon. Okay, this is a spoon. Now, if I just add a bubble, I put a bubble at this point of the spoon, just at the handle. I put a bubble. The spoon will never sink because there's a bubble over here. So by just having a bubble, which is an air pocket, which is free at the stage of manufacturing, in my mold, I just add an air pocket. Then this portion above the bubble will never sink because of buoyancy. It will always stay afloat. So the spoon will never sink. So simple invention like this, just by having a bubble which is free on the handle of a spoon, can actually be a patent. So let me just say, I did not file a patent for this. So any one of you all want to go and file a patent and benefit from it and monetize, please feel free. Okay. Okay. So just adding a bubble, something so simple, can actually be a very strong patent. So that's something you should also consider. So patent doesn't need to be something very super duper or too technical. It can be something simple. And as my slide says at the end, a patent can relate to a product. It can be a process, or it can also be a use. For example, a glove is a product. You can protect the glove itself. If the glove is stretchable, extra stretchable, and it doesn't tear, then you can actually protect as a product. You can also protect the process of manufacturing the glove. If you have a better process where you can, you have a cheaper process, a cheaper method, or a quicker method to make a glove, you can actually protect the process of making the glove, the quicker or cheaper method of making the glove, as a patent as well. So product can be protected, a process. You can also protect a use, as long as it is not obvious. For example, Panadol, when you take Panadol, it's to relieve headache. But if I now say I can feed chicken and fatten chicken by feeding it Panadol, I have a new use for Panadol. And I can actually protect this new use for Panadol because it's not obvious. Previously, it's to prevent headache. Now, I can fatten chicken by feeding Panadol to paracetamol or Panadol to chickens. I can actually provide a new use. Once I protect this new use, I can go to Panadol manufacturer and tell them, look, I got this new use. There's a new industry. You can actually now get into the agriculture industry as well and sell this to poultry farm, to chicken farm as a feed. So because you can fatten chicken, you can actually now come up with a licensing agreement with them that they would be able to sell for this. If you did not protect it under this new use and you talk to Panadol, they'll say, thank you very much for the idea, but I'm not going to give you any royalty. I'll sell directly to the poultry farm. But because you have it protected, they have to now start talking to you and they need to get license from you in order to sell the product in that particular industry because you have protected the use as your patent. Okay. Now, next, I'm going to touch on something very interesting.
Dr. Sri,
Yes.
we have a few questions. Maybe we
Boleh.
can read bit. Miss Najwa.
Okay. All right. For a written module on specific subject, for example, a module on psychology subject, that falls under which category of IP?
Okay, very good. Okay, now that falls under copyright. Okay, so a written module on a particular subject will fall under copyright. But I just want to qualify one thing.
Mhm.
There has been clients of mine who came up with some education system as well, or even psychology, and or they're working with autistic kids, and they say if they go through my program, and by going through my program, 5 kids come into my program, autistic kids, and all 5 kids are able to read much better because of my program, I may be able to even file a patent for it. I may. But you must bring out the science. That means if you show your program is doing something to the has some chemical reaction to the mind. I'm just giving you extreme cases. Huh? You can prove that it's got some kind of chemical reaction that it improves the mind in some ways of the student, and the student is able to read much faster. Then there's a science behind it. I can even protect it as a patent. But otherwise, if it's just a curriculum or it's just like a program, then you file it under copyright. And also trademark, because more like QDs or Krista, or Montessori kids, that's all a trademark because they have a teaching method and they call it under a particular brand, and then you protect it as a trademark as well, because people will start recognizing and saying, for my psychological, this one, I want to go for this particular ABC product because I know this is really valuable. So you need to consider trademark and also copyright. But if you can really show me some science behind it where it is improving the skills and we have data to prove all kids who go through it, 100%, they really improve in some ways, I may be able to have a patent for that method of teaching. I may be. Okay, but mainly it's copyright or trademark. Okay, any other questions?
Okay, next question. If you combine pictures from different sources and edit a little bit, is it okay?
No, it's not. I mean, because you're still taking, okay, Mona Lisa, you're taking Mona Lisa's picture. You're taking another copyright of somebody else's and you're putting it together. So the answer is you're still taking somebody else's work and you're putting it. So you still need to pay them some royalty. And then the end product may be a copyright of your own, the end product. But you have to pay the necessary royalty to the person where you're using part of their work. In order for you to come up with your end result, you need to use their work. So you will have to pay them. Okay, unless if it's something which is Creative Commons where they have said, I don't need any copyright for this because this I'm just giving it to anyone if you can use it freely, then yes, you would be able to use it. But as long as it's protected copyright work and you're using somebody else's work and you're coming up with, because we have got many cases like this, they come up with a catalog and they take some pictures from the internet and the pictures are all protected under copyright, and you just say, I'm just using just a small picture in one section of my catalog, it's still an infringement. Okay, so you will not be able to use it because you're still taking their work. Okay.
Understand?
Yeah, so you still need to recognize and you still need to give them credit, or you must talk to them and tell them. And then you can always have a kind of agreement with them and say, now, if I use my work and my final work, whatever I make from my final work, I'll give you a certain percentage of my royalty. They might agree to it as well.
Mhm.
You can always talk to them, but you have to give recognition, due recognition.
Okay, clear. All right, next. If I develop a questionnaire in research, what kind of protection I can take? Can I go for patent?
No. Okay, again, it's copyright for the question. So it's going to be copyright. And I've done this before also, where we protected a job portal. We protected a job portal as a patent. And then they have questions to see from the answers of these questions, they will know what sort of job will be more suitable for this particular candidate. So in that way, I actually file a patent because the questions will now identify what sort of candidate, what sort of jobs you will look for, and the system will go and look for the right jobs for you. So in that way, I've actually protected a patent as well because it's connected to, it makes it easier for somebody to actually look out for the most suitable job for them. But just the questionnaire per se, on its own, will be copyright. But I have actually done a patent as well, where it was incorporated together with the job portal. And again, you may even want to consider having a trademark for it. That means your questionnaire will have a certain name, and people will say, go for this questionnaire, but put a name for it, go for this ABC questionnaire, and that will show the type of personality you have. So rather than just saying go for a normal questionnaire, have a name for it. So like Anthony Robbins is a well-known motivational speaker. If he gives a talk on motivational, you'll pay maybe 5,000 to attend. You might even pay 30,000 ringgit to be next to the stage, just because you can be next to him. But if I give a motivational talk, even if I charge 50 ringgit, you might not come. Okay. So see, motivational talk is something very common. You can have all your modules, but the brand, Anthony Robbins, that will differentiate. Another example I can give is Professor Kim, who came up with Blue Ocean Strategy. So Blue Ocean Strategy was a book, it's the title of a book, but now they have training programs. If you say I go for a business training and it's called Blue Ocean Strategy, it might have more value than a training program by ABC, So Blue Ocean Strategy becomes a trademark, and I actually protected the Blue Ocean Strategy trademark. So you will need to protect the questionnaire as a copyright, but you may also want to consider having a brand to it and protect it as a trademark. Okay, next.
Right, next. Can I file for a patent if I have enhanced a traditional instrument with different materials, adjust it into a child-friendly size, and also improve its sound quality?
Sorry, can you just repeat that one more time? I just had a bit of distraction, sorry. One more time, please.
Can I file for a patent if I have enhanced a traditional instrument with different materials, adjust it into a child-friendly size, and also improve its sound quality?
Okay, now you use one word, improve the sound quality. So with that itself, I will try to convince the examiners, look, this is something special. Because the sound has been improved, the quality has been improved by them doing something. So that will be the argument to the examiner and say, now it's not obvious. It's not so simple for them to just change it, because by doing it, we have actually enhanced the equipment itself. So the answer is, yes, it's possible, because it's a traditional, I understand it's a traditional guitar, for example. One of the traditional guitars, the name is not coming to me. But if you have now modernized it and you have made the sound a bit better, it is possible. It is possible for me to consider, and I can convince the examiner to really consider as your tool. I've even protected games. Someone has come up with a new game. We've even protected under Section 13 of the Act says games cannot be protected, but sometimes what we will do is we'll not call it a game. We'll say a method for improving somebody's skills, whether motor neuron skills or cognitive skills, we will say something like that and we'll protect it. So that person who just asked this question, I think you should consider, if you really have something a bit novel, you should consider filing it as a patent, or I'm going to touch on something called utility innovation. Later, I'll touch on it. I believe you can have some protection. You should consider. So speak to your IP department of UKM and tell them that I said this, and you can actually qualify, if not a patent, at least a UI at some point. Okay, so it's possible.
Okay.
But sorry, I just want to add one thing to it. Okay, just one thing. So if someone comes up with a table, now they say table is normally made of wood, and I'm using now plastic material, and I'm going to come up with a table now manufactured using plastic, but plastic is not created by you. The answer is no, it's too obvious. Because if you can have a table made of wood, of course, people also know how you would be able to make plastic in that same shape, and you will be able to come up with a table made of plastic. You will not be able to. But if you can show that plastic at a certain size will be brittle and will just break easily, but you have a mechanism to strengthen that thin piece of plastic, then I can protect the mechanism, maybe the ribs that you need to add on in order to strengthen the table, then I can protect the ribs probably. The strengthening means of the table I can protect. So I'm just giving an example of, because when I say you just change the material, you can protect. Someone will just say, okay, now I have a wooden table. If I have a plastic table or metal table, then does that mean I would be able to file a patent? The answer is no, because it's too obvious. But if you can show that previously it's very hard for someone to make a plastic product which is very small because it's very brittle, it can break, but I've got a method of strengthening it, then I can protect the means of strengthening it probably. Okay, just that.
Okay, next, how to ensure our invention satisfies invention steps and novel?
Okay, so as I said, so that's a two test. There's a test to it. One is it must not be anticipated by prior. That means you must not find anything identical to it anywhere around the world. Any kind of publication, not necessarily patent, even a publication, or they take part in any competition, which is the same product out there, then that would diminish, or that would negate your novelty of the criteria. You will not fulfill the criteria of novelty. So you must not find anything which is identical. That's for novelty criteria. Now, for inventive step, as I said, the test is it should not be obvious to person skilled in the field. So to a furniture manufacturer, it should not be obvious, so only then you would be able to protect it. Yeah. Okay. Sorry. Come again. So does that answer your question? I mean, so that is the test. Obviousness, and it should not be obvious to a person skilled in the field, and it should not be anticipated. Okay. Next.
All right, we go for another question. How do we define the ownership of source code in IT industry? Is it merely by who own the copy of source code or required registration? If it is, how is the process of transferring the ownership? Is it by merely transferring a copy?
Okay, now the thing is, let me just, okay, good question. Okay, where copyright is concerned, where software is concerned, I mean, there's always this thought, software cannot be protected under patent, okay? Basically, software can be protected under patent. What we do is we don't protect the source codes. The source code is protected under copyright. But because source code is a mathematical expression, under Section 13 it says mathematical expression cannot be filed as a patent. So that is why the source code is protected under copyright. But what we have done is we also have a flow, and we have a block diagram of the whole technology or whole software. We'll protect the flow of the software as a patent. So we have done that. So a software patent together with some hardware, we will file it as a software patent. And not just go on copyright for the source codes. So we would be able to, firstly, we need to look at the technology and see what is the changes that is made. If it's quite substantial, we may be able to protect it as a patent and not just rely on source codes only, as copyright only, because it's going to be very limited protection. Because if you protect source codes as copyright, for example, you can have the move, you have a command move. I can change the move to jump, but it does the same thing. So it's very easy for one to just copy the source codes. So that is why we would sometimes, if it's possible and we feel there's enough inventive step, we will file it as a software patent and not just rely on copyright. Okay.
Okay, that's all.
Okay. Now,
You can continue.
I want to share something over here. This is one of the final parts of the first part of my talk. And this is touching on utility innovation. So in Malaysia, we have utility innovation. Other countries have, but in Malaysia, it's very unique. The criteria is a bit unique. Where I told you earlier, there's chair with 4 legs. If you come up with chair, if all chairs had 4 legs and you come up with chair with 5 legs, you cannot file a patent. I mentioned that. Tapi kat Malaysia, a chair with 5 legs, you can actually file a utility innovation. So even something that does not have inventive step, that means it's very obvious, can actually be protected as a utility innovation. So any invention that has got a slight improvement will fall under utility innovation. So researchers, you all should take advantage of this. If you just come up with a slight change, slight improvement, you would be able to file a utility innovation. So the person who asked about the music instrument earlier, you may want to consider if at all your change is very, it's quite obvious, quite similar to whatever the prior art is, maybe you might want to consider instead of patent, you just go for utility innovation. So in a UI, you can still have one patent, you can have one claim to cover all, whatever claims or whatever features that you're trying to protect under that one particular claim. So UI is actually fairly a good tool for you to use to protect an invention that is fairly simple. That means it's obvious, but it's new. Then you will be able to fulfill under utility innovation. As I gave you the example, a chair with 5 legs. If all chairs only had 4 legs, you come up with a chair with 5 legs, it is possible for you to protect it under utility innovation. So researchers, you're working out there, if you have got even a slight improvement, you might want to consider filing this. At least you'll have an advantage of building the business in Malaysia. Then you take it to other countries using your brand, because you may not be able to extend it in other countries, because other countries, the obviousness test or inventive step is still required. So you may not be able to get protection, patent protection in other countries, but at least you have first movers advantage. You have the protection in Malaysia at least. Okay. Now I want to get into 3 examples, then I want to go into an exercise, and then I want to touch on commercialization. Okay, I want to just share over here, if I'm talking to some researchers and you all are working on something, I just want to show how ridiculous some inventions can be out there that people actually spend money and file. These are all things that I'm not making up. This is actual inventions that was filed in US and granted. So I want you to look at your research work and be proud of your research work and probably protect your research work after looking at all of these examples, okay? So this is an ultimate weight loss program, they claim, Kononia. You have a tube from your nose to your stomach. You take a syringe, you feed air into your nose. The air goes into your stomach and will bloat your stomach up, fill your stomach with air, so you will not feel hungry. Does it really work? Patent office is not really bothered. But they actually filed a patent for this, and they said this is the ultimate weight loss program, and they protected it, and they spent money, and they got it filed and granted in US. Now, does it really work? I do not know. Have people actually used it? Are they still alive? I'm not sure as well. But anyway, so this is one invention that was actually filed in US. Another invention is this, bringing the dead back to life. This is more than 100 years. You look at this number, 465,000. Now it's 9 million something. So this is like a 100-year-old technology. So this one, you see, at this day and age also, you see newspaper articles where they say this person was pronounced dead, and after 5 minutes, the doctors found out that they are alive. Even now, you do read some news about, things like this, where after a few minutes, the person who's pronounced dead becomes alive, comes back alive. So what more, maybe 100 years back, when the technology is not as advanced, there's a possibility that somebody who's declared dead might come back alive because they're not really dead. So someone really felt so strongly for these dead people, because if you bury them 6 feet underground, I mean, if they are Hindus and you burn them, then that's end of the story. But this is more like those where you bury them 6 feet underground. They just felt very strongly, if you build and then they come back alive and they're 6 feet underground, how I need to save them. So he came up with this very smart device, and you can see a tube. There's a tube there. That tube is the smartest thing in this whole device. So if you come back alive and you are 6 feet underground, now when you have the tube which is extending out to the open air, if someone comes back alive, they will have now this breathing apparatus where you can actually breathe. You can get fresh air from the open air out there. so that you would be able to breathe. So it's very smart. But it also has one other problem. Now, even if you can breathe, but you're 6 feet underground, you're going to die eventually because you're stuck. So now this device again helps you, because when this device, you can actually now call out for help. You can say, tolong, tolong, and ask people to come and help you. But just imagine you're walking in a cemetery and you hear from the ground, tolong, tolong. Do you go and help or do you run away? But someone actually filed a patent for this and they thought it's necessary and they got it granted as well. Okay, that's just an example of crazy. Now, if I give this talk and Puan Najwa tells me the audience were not so happy and they felt a bit, they did not really benefit from this talk and I feel a bit down, dejected, I just go back home. I got this device to pat me on the back and to give me back my, to boost my moral back, you know, because in case I feel a bit down, this is a pat on the back apparatus. Someone actually filed a patent for this and they spend money. So to the researchers out there, you can see people are, you know, protecting even this sort of technology. If you have got some technologies that you think is worth protecting, do contact your IP department and try to get yours protected and monetize from it. And after this, I'll be touching on how you can also monetize on your technology. Okay. Now I'm going to have an exercise. I told you I'll be asking questions. So now let me check and see whether you have benefited from this past 1 hour that I've spoken about IP. And in general, under IP, you have trademarks that protects name, industrial design protects shape, patents that protects function, and copyright that protects artistic work. Okay, there's these 4. I'm just going to take a random item out, and I want you to tell me what sort of protection you think a client can get when they come to me on this. Okay, let me just give you this example. This is a remote control. Say, sebelum ini, if I want to control my aircon, I have to go and press the button on the aircon. So I came up with this invention where I have a remote control to switch on the aircon and change the temperature of the aircon. What sort of protection can I go for? When a client comes to me with this device, what kind of protection do you think I can give them? Can someone please give me this answer? There are mainly 3 types of protection here, 3 main. But the most important, what do you think? What sort of protection must I give them? The most important. Anybody? Anybody there? Because I just want to make sure that you all are benefiting from it. I mean, I spoke for 1 hour. I just hope you can give me the differences. There is a type of protection over here. I told you there's trademarks, patent, copyright, industrial design. What sort of protection do you think I need to give this client? Please try, yeah.
Industrial design.
Okay, you're right. Industrial design for the shape. Very right. But industrial design is one of it, but there's something else more important. What is the most important protection that I need to give? There's one very, very important.
The trademark.
Trademark is also that I told you there's 3, right? So you answer the 2. So it's trademark and industrial design is true, but there's another one which is more important than this. And I'll tell you when. What's the other one?
We can patent it.
Yes, you're right. Okay, good. And then it's patent. Patent is key. Patent is the most important. See, trademark is also important. Trademark I can protect, and also the industrial design. But I'll just tell you why patent is the most important. Because I told you this is the first of a kind. Because previously I need to go all the way and touch the device and change it on the device. So I have to walk all the way. Now I have a remote control that I can remotely, from sitting down, I can control the aircon as well. So the technology, I've got a good technology over here, so I can patent this technology. Now, once I patent this technology, I can license this to even other brands. This is excellent. I can even go to Panasonic and I can tell Panasonic, do you want this technology for your brand as well, for your aircon? They most likely say yes. And when they sell the product, certain amount of royalty you can make from them. So even if you see another aircon, any aircon manufacturers, you can go and sell this technology to them and they'll license this technology from you. So patent is key, the most important. Now, trademark is also important, no doubt. If it's Exxon, you can sell it for a certain price. If it's Samsung aircon, you can sell it for maybe a bit higher price. So in that way, the trademark is important. I'm not saying it's not, but the technology is key. Now, the shape, right, whether it is rectangular like this, or whether it is oval shape, or whether it is going to be square shaped, it really, it doesn't really matter so much. Yes, the shape is important in some ways, but it can also be square shaped. and you will still buy it. You won't say, oh, the remote control square shape, I don't want it. As long as the function is there, right? So the function is what you're trying to protect. And that's why I said patent is the most important. Industrial design and trademark is not wrong. It is also something I will protect for them, but the most important is patent. Okay, that's for this.
Yeah, sorry, I missed out on the part you said it's the first. Because I thought that remote control is so common already. It can't be
Yeah,
patent.
so that's okay. You're right. That's why I have to qualify. So that's the first, so that's why. Okay, now if I can just take something out randomly. Okay, client comes to me, pencil, and this is just a normal pencil. Pencil has been around, and they just come to me and tell me, I want to protect this. What sort of protection do you think I can give them? So it's not the first, okay? To answer, it's not the first. It's just a normal random pencil. Client comes and tells me, I want to protect this. What sort of protection do you think I can give them? There's mainly only one. Mainly one only. I can maybe try two, but most important is one. So what do you think is the most important type of protection that they can have over here if they come to me? Just
The
quickly.
brand? The brand?
The brand, very right. The trademark, very, very right. The one who said that, that's very right. It's only the brand, because if you look at the function, having a lead to write and all that, that's already common. That's why I said it's already common. So I cannot protect a pencil. It's been around for hundreds of years. Now, the shape, again, you see, maybe I can argue and say the shape is new, but I think the shape is also not so new. So I can even protect the shape. But the brand, yes, because you have created your own brand, I would be able to protect at least the brand. Okay, so only the brand. But if you're the first one to come out with the pencil, yes, I would be able to protect even the pencil. As a writing means, I can protect if you're the first one to do it. Okay, now there might be a question, a gentleman who asked, or somebody who asked earlier, what if they change this wood to plastic? That means the holder now is plastic and no more wood. Okay, and the holder is plastic, and then you have the lead inside. Maybe I can even file a patent for it, maybe, simply because you don't need to sharpen it. You can use the same holder again and again. You don't need to sharpen it. And then you just buy just the lead, and you insert the lead into the plastic holder. And then you hold, and that will be able to write. So maybe I can file a patent even for that, if the holder is going to be plastic. Okay. One more example, then I just want to see whether the 1 hour was not wasted and it was all used properly in some ways. Okay, now, pen is normal. Pen is already an invention, but now you have a pen with, you can change to 3 different colors. That no one has done before. A pen is already done, but to change 3 colors, no one has done before. So what sort of protection can I have for this type of pen?
Utility innovation?
I think I can even go for patent, I think. But you're right. Utility innovation, you're getting it right, because you're saying the technology, the function of it is what you're trying to protect. Very right. But I think I don't need to limit myself to UI. I believe even patent is good enough. But I like the way you think, because you feel pen is already there. This is just multiple pen. So it might be something very common. So you want to go for UI, but I still think I can argue and say it's not so common. I can argue and say that it might fall under patent. That is the strongest. That's the most important. What's the other 2 type of protection? The common thing. The other 2. Please answer so that at least I know. Okay, the brand, the trademark, because there's a trademark over here, it will be beneficial. And what is the final one?
Industrial design.
Yes, correct. Okay, that's it. Okay, that's it. Okay, good. Okay, that's it. So that's the exercise. So now that's the difference. So when you talk to anybody, please don't go and say, I want to trademark my invention. Please never say that, okay? Because then whatever that I've spoken all this while is just gone down the drain. Invention, when you want to protect your invention, it's under patent. So whenever you go to your IP department and you speak to them and say, my research work, I want to protect under patent, not under trademark. The trademark is for your brand. Copyright is for your artistic work. Okay, that's it. And now let me just go to my second part of my talk, which will only last about maybe 10 minutes the most, or 15 minutes. I'm going to talk about commercialization, what I've worked on for universities before. And also I want to just touch a bit on IP valuation. Okay. So Najwa, do you think we should just continue, or I don't think we should give a break, right? Just continue. I'll just continue. Okay, fine. So for funding, see, one of the things is, I mean, to the researchers out there, and I think I even got the question first where they said, should the government fund or should the government help researchers with brand names? I'm not so sure about trademarks, whether the government really needs to help, but where technology is concerned or research work is concerned, yes, probably the government definitely needs to help in order for us to enhance on our research work. So so these are some of the source of funding. Whenever you have a good idea, you can use your own money, personal investment. I've got clients who does that. You can go to a bank and get some loan, but this is a bit challenging. Now we're trying to tell banks to recognize even research work or IP work, but that's quite challenging because banks will always like to see something that is already workable rather than going for something that is not tested yet. Angel investor, VCs are some of the ways you can go forward. I also mentioned about Raju. There's some government funding like MOSTI, MTDC, Cradle that you can also try to get some funding. Now, IP commercialization, some of those things that I've actually worked on, and please feel free to ask any questions that you may have. This is with UTP that I worked on. This was, I think, in 2013 or 14 when Dato Baka was the Deputy Minister of MOSTI. So UTP actually came up with this, they call it generator, eco generator, tapi it's more like a power bank, a bigger power bank, but they call it eco generator, to be used in Pasar Malam. So why it's good is because Pasar Malam is using diesel generators to light up the stalls or to have fan. To have fan or to light up the stalls, they use diesel generator. Two problems to it, or three. One is it's noisy, so noise pollution. Fume also is emitted, so there's also it's not good for the environment because there's fumes which is transmitted to the air, so that's also not good. So there's pollution to the air, and there's also another problem where it is for petrol generators they need to spend about, I think, 3 ringgit every day to have the generators work because you need to fill it with petrol. So they have to spend about 3 ringgit for it to run the full 4-5 hours at night. So to them also it's a bit expensive. So we came up with this solution where to charge the power bank in a way, eco generator, to charge it, it's going to cost only 50 cents. So to the Pasar Malam owners also, they're saving 2 ringgit 50 cents because previously every day they must spend 3 ringgit. Now they only spend 50 cents. So in that way, it's very good. Then, as you know, when it comes to this kind of eco generators, which is power bank, you do not have any fumes emitted to the environment. So it is clean. And there's also no sound. So there's no sound pollution as well. So it was really a win-win situation. So I managed to go and get Community Innovation Fund. And then I spoke to the minister, and minister said, okay, I got a Pasar Malam in Tangga Batu. Why don't you come and just test this out in Tangga Batu? We'll get these funds, give this 30 units, or was it 50 units, to all the Pasar Malam owners, and we'll use this as a test case. If it's successful over here, we're going to now replicate it and change the Pasar Malam, all Pasar Malams. So I got involved in this project, and I went to this Pasar Malam in Tangga Batu, and I gave them 1 unit at no cost for free because the government gave out this Community Innovation Fund, CIF fund, for 250,000. So we managed to get, I think, 50 units, and we gave it free to the community. And we were supposed to come back after 1 month to see whether it is really workable and it's working for them and everything is good. And we need to take some data to prove to the government this is really a good project. We can save the environment and also noise pollution. And even the Pasar Malam owners are also benefiting from it. So we should replicate this model with all the other Pasar Malams. After 1 month, I went there. I'm just explaining how commercialization can sometimes go wrong. I went back after 1 month, and I was surprised to know many of them actually sold the units. So someone just came and gave them a few hundred ringgit, and they sold the unit. So at the end of the day, we could not really get the data to show that this is such a good technology where it's a win-win situation for everybody, because we did not take into consideration that the Pasar Malam owners might just sell the units to some people for a few hundred ringgit, because for them, they're not looking at the long term where they can save 90 ringgit every month. They were not looking at that. They were just looking at if they can make 200 or 300 by selling this unit. They just did that. And they just said it was stolen. it was taken by somebody else, and we really could not get the data, and the thing was a bit of a failure, although we thought the invention was quite good. Okay. Next is on another invention that I worked on, and this is it's called the transit rat killer. Sorry. It's called the transit rat killer. It's a garbage bin. So this is not any university lecturers. It's actually garbage collectors who came up with this invention. I'm not joking. This was in, I think, again, maybe 2014 or 15. Sorry, 2013. They won the best invention under KIK, Kumpulan Innovative and Creative. This is a government initiative to encourage government agencies to come up with innovative ideas in whatever everyday work that they're doing. So these are garbage collectors in MPK, Majlis Perbandaran Kuantan. And they actually came up with this solution because they said, when they see a garbage bin, there's always a hole at the bottom where rats are making a hole to go in to eat the rubbish. So they're always making a hole. So the garbage collector very smartly said, why not I just make a hole, but I'll put a one-way valve. He came up with a novel, very smart one-way valve. When the rat goes in, it cannot come out. So rather than the rat making a hole, he makes a hole. And then the garbage bin will end somewhere. There'll be a bit of space where the garbage bin will end. There'll be a bit of space where the rats can go in, and it'll be like a housing for them where they'll be trapped inside the housing. The garbage is on top of a bit of the space. So that was a very smart idea that they came up with. We really liked the idea. We took it, and then I told them, let's try to commercialize it. So I actually went and spoke to Alam Flora. Now, many people were skeptical. They said, oh, all this is controlled. The government will not want to simply just give this to anybody, somebody else benefiting. There's a lot of politics in it. But actually nothing of that sort. We really went to Alam Flora. Alam Flora saw the invention. They liked the invention. But they just said, on the practical side, I cannot help you. And they explained why. They said, the garbage bin, you have the rats trapped at the bottom. Now, if we tilt, because whenever we are cleaning the garbage bin, we have a truck that comes and tilts the garbage bin. So when the garbage bin is tilted and the rats are there, the urine is going to be poured onto the ground. And the urine is which is dangerous. Okay, so when that goes to the ground and cats go and touch it or eat it, that will take some disease, and you'll spread disease. So we will not be able to do it. So unless you have another mechanism to change the bottom part, that means you must have a cartridge to change the bottom part. But if you have a cartridge to change the bottom part, who's going to go and change the cartridge first before you tilt? So they said on the practical side and the cost-wise, we really cannot. Although it's a fantastic invention, but we cannot do it because we already have an SOP how to clear the garbage bin, and this will not fall under the SOP. So that is why it was not possible to actually move this technology. So again, I'm just giving you an example of how a technology is really good, but it really did not move eventually. Now, the next invention is a circumcision device, alat sunat. They have a few alat sunat, but this is an inventor from Johor, a 70-year-old doctor, Chinese doctor, who came up with this circumcision device, and he came and protected it with us. What I did was, I had a client who is in the medical field. He produces products, medical products. So I linked them up, and this was successful. They spoke, they liked it, and they started manufacturing this product for this particular client, and they started selling it. So they had a bit of, they tested the product out, the product worked very well. And then they protected it not only in Malaysia, but in a few other countries, and they successfully commercialized this technology. And they've even licensed this technology to other players as well in other countries. So what I'm trying to say is, when the invention came in, the inventor was a doctor, so he didn't really have the business skill. So what we did was we just linked him up with another client of ours who has been doing this business of distributing medical products. So they really liked it. We linked them up, and it worked out, and they managed to commercialize the invention in this manner by collaboration. So that's something, when you come up with your products in your university, one of the things you can look at is collaborating. I mean, if the inventor really has got the entrepreneurial skills, they want to move on their own, fine. I will not want to push the researchers to become businessmen if the researchers have no interest. I think researchers should just do research work. Then they give it to the TTOs, your Technology Transfer Office. The Technology Transfer Office can move the invention by virtue of like what we've done over here, collaborating with some other parties who are already in this business, and then come up with a nice, good licensing agreement and license the technology to them, where it be a win-win situation for both parties. So that's something you can actually look at. And this is a success story that we have actually commercialized. Okay, any questions on commercialization? Okay, if there's none, then the final part is IP valuation. I just want to touch on it. This is something new that we are trying to push. When you look at your assets, intellectual property, right? Property is an asset. So when you have your house, which is a property, you can go to the bank and get a loan for your house. Because the house is an asset, the banks will recognize that asset and they'll give you a loan based on that particular asset. They'll do a valuation and they will say, okay, your house is valued at this price because the location is over here. The size is this much, your value is this much. I can give you a loan based on the property that you have, whether it's a house or a factory or land. Similarly, what we're trying to push now is when you have your IP, that is also an asset, but it's an intangible asset. You can't touch it. It's an intangible asset, but it's an asset nevertheless. So why not? We're trying to encourage the bank. Look at it and you give loans based on the IP assets. So that's something we're trying. We're talking to the banks. Foreign banks have already started recognizing this. Foreign banks are doing it. Especially in UK, there's a bank called NatWest. They're doing it. So we're trying to encourage the local banks also. You should also consider doing this. So on IP valuation, this is important because whenever your researchers are coming up with any of your work and you protect it as a patent and you cover in certain countries, you can do a certain amount of valuation so that when a VC or an investor comes in, you can have a value for your particular technology that they have to put in order for you to benefit from it. Okay? Okay, so just that's about it. I want to touch on IP valuation.
Dato, Sri, before we proceed for the next, I can see there has one question from the participant. Okay, may I read this? Okay, hi, sorry. Sorry. Okay. Hi, Dr. Sri. May I ask? First, they have two questions. The question number one is there a possibility to IP a translated English to Bahasa questionnaire that is widely used, possibly copyrighted, as a part of an assessment protocol? And then the second one is for a newly developed standardized clinical protocol, could we trademark and copyright the protocol module and also patent the apps that is developed as a part of the module or protocol? Thank you. That one is question from Dr. Hana Hamzai.
Okay, doctor, I'll answer the second question first. Now, you correctly said it's going to be trademark and also copyright. So that's clear. Now, when you have an app, can you just file the app for patent? Depends. I need to find something smart to it. I mean, if you have some smartness to it, you have some algorithms, yes, I would. But if you just computerized it and you just have it in an app version, it may be a bit challenging for me. So it'll still fall under copyright and also trademark. But as I said, if your app has got some amount of smartness to it, you have some algorithms where it can do some kind of calculation and it'll give some results, yes, then maybe I might consider the apps as a patent or a utility innovation. So I need a bit more information, but definitely trademark and copyright. The first question, I didn't really get the first question. Can you just repeat the first question of this doctor?
Hello, hi, Dr. Sri.
Yeah.
Okay. The first question is actually from my teammate. There's actually a standardized questionnaire being used as an assessment protocol in their field, and then they have collaborated in the research to translate the questionnaire into Bahasa Melayu. So the question is that, is there any possibility to IP the Bahasa Melayu questionnaire?
No, answer is no. No, of course not.
Okay.
Because it's so obvious, it's so straightforward.
Right.
You can have copyright, of course. You'll have copyright for it. But you must also recognize the person who created the questionnaire in English.
Yep,
And you
definitely.
have to, and then you can also put your, because you translated it, you can also go as a, because with their consent, you can also be a co-author of that particular questionnaire because you have done the translation and you have put some input. So you can be a co-author together with them, but you definitely need to recognize their work as well. So you can put your name in and you can be a copyright product but nothing else, just copyright on the translation, but with the consent of the original creator of the work. Okay?
Yep. All right.
Okay.
Thank you so much.
No problem at all. No problem. And then as you were asking about the app, I need a bit more information. If you really have some smartness to it, some algorithms in it, maybe we can consider. Okay?
Okay. All right.
Okay. Any other questions?
Okay, there's one question. Can we copyright the innovation product first, then seek for trademark and patent?
Okay, now the thing is this, trademark, no problem at all. The answer is yes. The answer is immediate. You can even file a trademark after 10 years if no one has filed it before you. The problem here is the patent. Because when you file a patent, I also mentioned one of the first criteria, it must be new. So what happens is, I have many cases like this, especially from researchers, because researchers like to publish. For them, publishing is important. So they will publish the work and not file a patent. So when they publish the work, the clock will start ticking because you have 1 year from the date you publish to file a valid application. Once you miss the 1 year, your own publication can be used against you because when you file your patent after 1 year, they will cite your publication and say, look, there's already a technology which is similar to this that was published 1 year back, more than 1 year back. Your argument will be, yeah, but that was my work. So it's obvious that's my work. I published it, but they'll say, too bad. Because once you publish, it's already public domain. It's already known to the world. It will destroy the novelty of your patent application at a later stage. So when you are going for copyright, you need to publish your work in order to get copyright. So if you're going to do that, you're publishing your work, you will have this issue. So if you do it within a year, it's possible. So that's something you need to consider. So I would rather, if it's really a very good technology, you should really consider filing a patent for it on an immediate basis rather than publishing it. Okay, if it's really good work. But if you feel commercialization, it's not really there yet, it's fundamental research, you don't really need to go ahead and protect it as a patent yet, then yes, fine, you can publish it. Okay. But keep that in mind, your clock starts ticking once you publish. You have 1 year to file a valid application. Okay. All right. If we only have about 5 more minutes, if there's questions you can take for the next 5 minutes, otherwise, probably we can end it here.
Dato', I realized that you shared that there were quite a number of inventions that were patented, but actually they were kind of like strange or even funny, like what you shared earlier.
Oh, yeah.
So when we create something, should we straight away go for applying for the patent without even checking whether it is actually sustainable or even if, let's say, that whether the thing works? Because now there's a competing demand between publishing, which is part of our KPI, and also getting a patent for it. I mean, like, I know that the process to get a patent probably is quite long and also requires money and a lot of like documentation required. So it's a lot of things that needs to be considered, right?
Oh yeah, okay, you're right. I mean, okay, firstly, if you're filing a patent, even when you're filing a patent and you come to us and your departments will also know, there will always be a search. It always starts off with a search first. So we'll make a search and see whether the invention is new around the world or not, worldwide search. And then we'll come back to you. So if it's something obvious, we'll tell you this is something obvious, you can't file a patent. Okay, that's one. So even if you're going to file a patent, we'll always make a search first to see whether it is something that is patentable. That's patentable. Now, the next question is, yes, but even if it's patentable, but does it have value, commercial value? So that's something you need to ask yourself. And the university also, the TTOs can also look into it. So many years back, I mean, the universities were going for RU purposes. They were filing quite a number of applications because they wanted the numbers. But now it's different. They are going for quality. So when they're going for quality, they'll see which one has got potential for commercialization. That's the one they're protecting. So I don't know what's the internal arrangement. Maybe in your assessment, they will also be asking what is the market value for this and how can you grow this business? And I think that might also carry some weight, some bearing in order for you to apply for a patent, because as you said, patent is a cost. You need to see whether you'll be able to read back this cost by commercializing it. So that's something internally, I don't know, your IP department together with the TTOs have to have a mechanism where they'll see whether this work has got potential, commercial potential or not. So one is the IP part. That one is fairly, we'll just make a search and tell you, yes, we can file a patent and you can get a patent granted. But even if you can get a patent granted, but if it has no value in the patent, does the university still want to file a patent just for the numbers, or do they want to file quality? That really depends on the university's policy, IP policy. I can't really comment too much on it.
Thank you. Thank you for sharing your insights.
Okay. Anything else? Okay, if there's nothing else, then thank you very much. I hope it's been beneficial and I've shared with you the terms that people use. So please don't use the wrong terms after this. Use the right terms. And also when you seek for protection, make sure that you are getting the right protection for yourself. Now, I did not really touch a lot on patents because I really didn't know who the audience are. But if you really need a bit more guidance or a bit more talk on patents, that means how do you look into a patent claim, a patent specification? How do you know whether the claim is drafted well? Probably you can do another session at some point, but that's mainly to the researchers so that you understand what is a good patent. I'm not going to teach you how you can be a good drafter. That's going to be difficult, but at least the draft that you get from whoever did the work, you can know whether it's doing justice to your creation, whether they've protected it well or not protected it well. Maybe we can look into that in the future. Okay, thank you very much.
Terima kasih diucapkan kepada Datuk Sri Mohan K di atas perkongsian ilmu yang amat bermakna ini. Terima kasih juga kepada hadirin sekalian. Semoga kita semua dapat meraih manfaat sebanyak mungkin dari perkongsian hari ini. Untuk makluman hadirin sekalian, sesi Bicara Inovasi ini akan diadakan pada setiap bulan dengan tajuk yang berlainan. Jadi semoga kita berjumpa lagi pada bulan Februari ini. Terima kasih kepada semua dan warga UKM dimohon untuk scan